and say hello, everybody. And thank you for joining us for today's Mixpanel webinar on GDPR and Analytics. My name is Jade, and I am a Relationship Manager at Mixpanel. Shortly, I will be handing over to my colleague, Peter Day, who is the Head of Privacy and Security at Mixpanel. And he will be giving us a short presentation on the subject for today, which is GDPR and Analytics. And during the presentation, we would like to ask you, of course, to share some questions with us in the Q&A function, which is at the bottom of your Zoom screen. We will be leaving ample time to answer your questions at the end of the presentation. There is also a chat function. I can see 1 or 2 questions in there as well. Don't worry about that. We will be looking there to see if we've missed any questions and trying to get to as many as possible. The webinar is being recorded and we will be emailing it to you in the 24 hours after the session today. If you do have any technical difficulties, everybody should be on mute, you will have noticed, but if you are having problems hearing, you can check your audio settings on the bottom left-hand side of your Zoom screen by clicking on the little arrow next to the microphone, and you should also be able to connect to Zoom via your mobile phone. So I mentioned questions today. We're expecting a lot, which is great. We want lots of engagement from all of our audience members today. If we don't get time to answer all questions, don't worry, we will be collecting them and trying to address the more broad-based ones on our community. The QBQ platform will be collecting and posting the most common questions up there, along with some responses from our legal and privacy teams. Having said that, although Peter will explain to you in a moment that he is a lawyer and his background is very much in law and legal advice, today's format is not the right one to ask any specific legal questions, but more for us to give additional context and clarity on the current landscape on GDPR in general, best practices, and how they can be applied across industries and across different company verticals. And with that, I'm going to hand over to Peter.
Well, thank you, Jade, and good afternoon and good morning, anyone joining from the United States. As Jade mentioned, my name is Peter Day. I'm the head of Mixpanel's Global Privacy Program and our Information Security Program. Prior to joining Mixpanel, I worked as a privacy officer for the Federal Reserve System. And my role at Mixpanel involves leading a cross-functional team that works in data protection, information governance and security, and privacy. As Jade mentioned, I'm a practicing attorney. I graduated from the Indiana University School of Law in Bloomington. And just a little bit about me, I'm an avid surfer. So I hope that if there are any other surfers out there that we can somehow connect and talk through privacy while surfing. So I wanted to start at sort of the highest level and talk through what are we all here today to discuss. And in a word, what I'd like to start with is consent. And I've chosen consent because I think it's really a key principle to understanding European data protection law as it applies to analytics. And it doesn't mean that there aren't other important topics, and we hope to have more of these webinars where we can share information with you and have a broad-ranging discussion about what it means to collect and process personal data. But consent to me is really the key to starting that conversation. And so today we're going to spend some time walking through the legal framework of consent, talking about its background, where it comes from, so that we can understand some of the techniques, tools, and suggestions that I will outline at the end of today's presentation for implementing a consent-based and privacy protective analysis strategy. So where does consent come from? It's really been in practice since the 1970s when laws began to emerge and information governance strategies began to emerge in Europe and the United States around putting data subjects in control of their information and giving them a modicum of voice into how personal data was collected and processed. But consent really came to the fore, in my opinion, in the early 2000s with the adoption of the European Union's Charter on Fundamental Rights. And since 2000, EU citizens have all had a fundamental right to data protection, and part of that includes consent. The other reason why I think it's important to start with consent is because it does vest control over personal data in the data subject. And as anyone interested in data analysis knows, you really have to have data to perform data analysis. And if you don't own or have exclusive control over that data, you're going to need to get it. Without it, it would be a little bit like having a bicycle without a front wheel. And so consent to me is quite important. So as I mentioned, we'll walk through some of the context you need. We're going to do some high-level background first, and then we'll pivot into some of those best practices. So I mentioned consent is part of the fundamental rights architecture that governs data protection in the European Union. Article 8.1 of the European Convention on Charter on Fundamental Rights expressly calls out data protection as a fundamental right. And it's distinct from the broader concept of privacy. While privacy is certainly important and enshrined, data protection is a bit more mechanistic, and it goes beyond what we would traditionally think of as being privacy rights. It doesn't necessarily apply only to information about the private life or personal lives of data subjects. It gives them other sort of operational rights. For example, rights to be told, rights to opt in, rights to give their consent. And those types of mechanistic steps make it a perfect candidate for design thinking. And what I mean by design thinking is you can build a system, design a strategy, come up with a business plan that protects the fundamental right to data protection and meets your objectives. So I wanted to talk now briefly about the legal framework underscoring data protection rights and consent. And they flow from three primary sources that we'll be talking about today. The first is the Charter on Fundamental Rights. So since 2000, as I mentioned, European Union citizens have had a fundamental right to data protection. That's principally enshrined for our purposes today in two pieces of law that have been published by the European Commission. The first is the e-privacy directive from 2002. Most famously, the cookie directive, which we'll discuss a bit later in today's conversation. And then the second one is the GDPR, which really needs no introduction, but sets out in rigorous detail and often some frustrating vagaries too, what exactly it means to apply data protection principles, what it means to get consent, and how to operationalize a data protection regime within the European Union. So consent, to break this down further, is a key component of the European data protection landscape. It's certainly present in the e-privacy directive. You can see it in Article 5.3. It's also peppered throughout the GDPR, and we've listed some of the key provisions there. It's defined in Article 4.11 of the GDPR, and I've reposted the description here, but as you can see, just reading it, it's very difficult to obtain because it measures an objective standard. It asks you to look at a data subject's intent, look at what they know, look at what they understand, and somehow capture that. And to capture that through an affirmative act. Now that might be intimidating, it might be scary, and we'll talk about that a little bit later. But I'd like you to pause just for a minute and think about the mechanistic character of this. There are a series of steps, a process, if you will, that needs to be followed in order to demonstrate consent. And I think that's a key part, as I mentioned earlier, about capturing design and building a program designed to protect the fundamental right to data protection by capturing consent. That said, its mechanistic character also makes it a relatively easy target for enforcement actions. So because it can be objectively measured and because it seems to have this process-like approach to data protection, regulators can easily see and audit and review your consent strategy to determine whether or not you've complied with the GDPR or the e-privacy directive. And so that would mean that poorly designed consent management programs, poorly designed analysis strategies could be targets for regulatory enforcement. With this diagram, I'm hoping to further flesh out what I mean by the mechanistic character of consent. And looking at this, what I've done is highlighted 4 key pillars that individuals hoping to capture consent need to identify, from users of their websites, visitors to their websites, applications, prior to collecting their personal data and processing it, either via cookies or via some other mechanism. So the first component is that consent has to be freely given. The data subject cannot be coerced into giving consent. This is most commonly seen in situations where there's a significant power imbalance between the data subject and the collecting party or data controller. You see that often with employer-employee relationships, but you could see it in other relationships, and European regulators have been careful not to limit it exclusively to the employee-employer basis. Regardless, you want to make sure that your consent is freely given. You're not forcing data subjects to give it to you. It needs to be specific, and we'll talk more in detail about transparency. For now, what I would just want to highlight is that specific consent means that it's tailored to a precise purpose. It's not just give me rights to do whatever I want with all of your data for all time. It needs to be more tailored than that. It needs to be informed, and again, we'll talk more about this as well, but data subjects have a right to be told what you're going to do with their data and why you're going to do it. And this one, clear, you might say, well, that makes sense. It's obvious, you want to explain what you're doing. This is getting increasingly challenging. As technology stacks grow, as information and use cases expand at a rapid clip, it can be very hard to deliver clear, concise notices that are written in plain language that an ordinary person can understand. And so this clarity requirement actually takes a good bit of thought and planning. All of these things can be captured in an objective agreement. And what do I mean by an objective agreement? It means a separate legal document or consent form that users select and click with no pressure to do so, no pre-checked boxes, nothing like that, that shows that they've met all of these 4 criteria. And it's captured, it's auditable. I've got my little check mark there. That's a key component of consent. And once you've got that, you have valid consent. If you don't have that, it's very difficult to argue that you have gotten valid consent to process personal data from a data subject. So looking at all that framework, and I know we've just touched on it, it's been a very sort of high level discussion, but I think a couple of things emerge, and the most obvious one is this is not easy stuff. How do you obtain these consents from the thousands and thousands of visitors to your website? How do you obtain them from users of your mobile app who just want to get to content, just want to start playing their video game? These are very challenging questions. And I think it's important at the outset to acknowledge that they're hard to grapple with. This is a data governance challenge. It's a privacy challenge. It's protecting data subject rights, but it's also a UI and user experience challenge. And giving all these consents, having all of these banners, having a variety of notices and boxes that need to be checked and rechecked constantly has led to an extraordinary increase in the levels of opt-outs and opt-ins that users in the European Union are seeing, and it's caused some frustration. But again, going back to my earlier points, I think it's a design problem and one that we're going to talk through some techniques and approaches to solving today. Finally, I would like to flag one other challenge that's emerging in the area of consent, and that's a lack of regulatory consensus within the European Union. Students of the e-privacy directive and the GDPR and even the Charter on Fundamental Rights know that these pieces of legislation were adopted and drafted and put in place to try to harmonize data protection practices across the European Union. And what we've begun to see since the GDPR is some atomization amongst the data protection authorities in various jurisdictions over how to treat consent, how to gather consent, how to use trackers, cookies, and the like. And that's made it even more challenging to design an effective consent management strategy. So we at Mixpanel are hoping that there'll be more harmonization efforts across the European Union, and that the spirit of the GDPR, which was to bring an objective, harmonized standard, will continue to reign. But for the time being, that isn't really the case, and the trend lines don't support that at the moment. So not to make it even more challenging, but that is something that you should keep in mind when designing your consent strategy. So I've talked a lot about an analysis strategy, consent strategies, getting consent. So really, where do we begin? Where should we get started? So this is my first piece of advice, is don't panic. There are lots of ways in which you can get consent, and you can use design thinking, you can use compliance controls, you can use existing technologies to get it. It's not something that you should freak out about and decide, hey, I really can't collect information from EU data subjects, and my analysis strategy should exclude them. So the next thing we recommend is that you begin to inventory, and we mean this in a very rigorous sense, the types of information that you want to collect and are collecting. This means taking account for the cookies that you may be using. It means taking account of any SDKs or device fingerprinting technologies you're using. It also means taking into account where those systems are feeding information into and what you're doing with it downstream. We'd also really recommend at this point taking a close look at whether you're doing client-side versus server-side tracking, and whether you can pivot towards a more server-side approach. But these all have to be considered at the outset of developing your analysis strategy in order to build in effective consent management. Once you've gotten a good inventory of what you're collecting, the technologies you're using, your rough plan of what to do with it, we'd recommend pausing and taking some time to get to know your local data protection authority. Now, this doesn't mean going down to the pub for a couple of rounds with them. It means taking a look at their published documentation, looking at what they've said, looking at their opinions on things, and getting a good sense of where you think they're headed. This may involve working with stakeholders from your legal department. It may involve working with outside counsel. It may involve, if you're lucky enough, talking to your data protection authority. But we do strongly recommend that at the outset of designing your consent management and analysis strategy, you spend some time getting to know what they're thinking and where they're headed. So we've gotten some of that early considerations out of the line, and I think that we should start with consent management. I see consent management, and that is gathering all of those elements, making sure that you've gotten freely given consent, making sure that you have an objective agreement, making sure you're not using pre-checked boxes, making sure that that's audible and trackable. That really is the key to an effective analysis strategy. And I think, and maybe this is just my bias as a privacy lawyer, but I think when you're building an analysis strategy, these types of concerns should be front and center. If you're thinking about it from an agile perspective, you've got your Kanban board. Consent management needs to be one of the early gating items and needs to run for the entire length of the project when you're deciding to stand up a new analysis strategy. And to me, the justification for that is you cannot process personal information without consent in the European Union. And so you have to have a defensively designed consent management program to obtain your analysis goals, because you need it to obtain your data. One of the components of this consent management program that we strongly recommend is empowering true choice. And what we mean by that is using tools, techniques, software, technologies, and administrative controls to ensure that data subjects have a right to give freely given consent. So the days of pre-checked boxes, the days of cookie walls and other types of information in exchange for data that is very opaque and difficult to understand for data subjects, those days are really coming to an end. And while it's not expressly barred in all European jurisdictions, I think the trend lines are pretty clear. And so the days of doing that really need to come to an end. And we think that you should design a consent management program that's aimed at empowering that choice and designing tools and techniques that can continue to capture relevant information without forcing users to give up all of their data. Finally, I think, and I've mentioned this a few times throughout today's discussion, consent management programs don't need to be perfect. They need to be defensible. You need to make a good faith effort that's thought through the various risks, thought through the various techniques, thought through how your regulator may consider consent management programs and what they're looking for, and then design a program. You're never going to design a perfect consent management program, and one doesn't exist. And so really don't aim for the perfect, aim for the defensible. And look at managing your risk, not completely eliminating it. So the second broad theme that we see at Mixpanel and that we recommend is really tailoring your data collection practices. And what do we mean by that? The GDPR has a very famous provision on data minimization. And what that means is only collecting the information you need to accomplish your task or to provide your service. So if you want to understand an aspect of how your product is used, if you want to understand how users interact with your application, you really should think hard and long about what data you actually need to accomplish your goals. And I think this is a key component of consent, because consent is specific to types of information. And so if you know we only need this type of information, you only need to get consent for that type of information, versus taking a broader stroke, which is trying to get consent for all the information without tailoring it down first. And this comes back for us to relevance. So is the data that we need to complete our analysis strategy, to understand our product, to understand our website, is it relevant? And are the information resources we're hoping to collect relevant to that purpose? If they are, that makes getting consent much easier, because you can explain why you need it. And we'll talk more about that as we get into the conversation. And I think this is a very important point to talk through when you're tailoring collection. Is analysis is not an excuse for just collecting information and hoping to find some pattern. It doesn't really replace thinking or pushing through concepts that you need to understand for your business. And so we think that a privacy-focused and data protection-focused analysis strategy is actually the way to go, because it helps you separate the chaff from the wheat. It helps you identify the information you really need to obtain your goals, and then consciously cut out the rest, so you know exactly what you want to collect and can build a better data protection strategy and a better analysis strategy on top of that information. So the third thing that we see a lot at Mixpanel is questions around transparency. People are asking us all the time, what do you need to put in a privacy notice? How do you capture consent? How do you inform data subjects of their rights? And we could spend an entire webinar talking through this, but I did want to flag a few high-level points. So the first is we strongly recommend focusing on user experience and expectations. So the GDPR has some guidance on precisely what you need to put into a privacy notice. That can be separated out for consent. But what we think is important is to make sure you've disclosed in a relatively robust way what information is needed, what you're doing with that information, how that information is going to be collected and processed, i.e. is it going to be cookies, is it going to be used by an SDK, or are you using device fingerprinting? And then what third parties are you using to collect that information? You know, are you using something like a Facebook or a Google to use third-party cookies? All that should be disclosed and done so in a very transparent way, so that users can understand, A, what you're doing and their expectations are set, but you're also giving them the experience that you're privacy protective, that you value data protection, that you understand the rules, and you're willing to meet data subjects there. So on this point, we strongly recommend calling out any trackers you're using. If you are using SDKs on your site, if you're using device fingerprinting, if you're using cookies that are deployed by third parties, we recommend that they're expressly called out. So you would have a line item that says we are using this tool, this is what we're using it for. Days of sort of much broader, more generic and vague notices I think those days are numbered. I think we're really looking at much more specificity that will be required in consent disclosures. And I don't see this as a bad thing per se. I do understand it to be an opportunity to push your brand, to show that you're privacy protective, that you value data subject rights, that you understand how these could be concerning to users. And you can bundle that all up into a very robust privacy policy, set of privacy practices, and show the world that, hey, we're a responsible company. We take data protection seriously, and it's part of our brand. So another topic that we hear a lot about at Mixpanel are cookies. And this has become a very hot topic. Really prior to COVID-19, it has died down some in light of COVID-19, but European data protection authorities, many data subjects, consumer groups on both sides of the Atlantic have raised significant questions about the use of cookies and how they're to be used, and what types of information are being collected by them, and how consent should be managed in the cookie space. And so for us, we see this as an opportunity to really build a new cookie jar. So as you're building your consent management strategy, designing your analysis strategy, we think this is a great opportunity to start thinking through how you're using cookies. One of the things we hear a lot of is, well, your SDK or your device fingerprinting solution is not a cookie. Well, it's not really the case. So under Article 5.3 of the ePrivacy Directive of 2002, a cookie is really anything that accesses information stored on, the directive uses the term terminal equipment, but we prefer computer or mobile device. So any technology that's writing to any part of the memory on a computer or a terminal device counts as a cookie. And this is an extraordinarily broad set of technologies that arguably includes SDKs, includes things like pixel tags, device fingerprinting. So it's quite broad, and that really requires, in our view, a rethink of how you're collecting consent to deploy and use technologies that capture that type of information. And this is going to lead, in our opinion, to a revision of cookie banners. So again, this comes back to your particular risk tolerance, but we think that cookie banners do need to be revised. Many of them were pushed out 3 or 4 years ago. Some of them were updated in light of GDPR, but we think that they need to be updated again to provide more specific and granular levels of control and better and clearer disclosures. So that you can comply with the sort of mechanistic requirements of the GDPR's consent management framework, but also so that you can signal to users that you are a privacy protective brand and that you understand data protection. That said, we also are strongly encouraging our customers to begin focusing more on server-side tracking. So client-side tracking, which would be cookies, your standard kind of devices that an end user can see that uses an end user's computer or smartphone to process and store some information. That's helpful and it has its use cases. But if you are using these techniques to monitor use on the server side, these are systems that you control that do not require or depend on a device's local memory, you have much broader rights, and it can be easier to obtain consent in those cases, and you do not have to worry about cookie banners and things of that nature to the same degree. And so when you're designing your analysis strategy and looking at consent management, we're really strong advocates here at Mixpanel of exploring your options to gather information server side. So as we move forward, another area that we're very focused on at Mixpanel is data mapping. And this is something that we strongly recommend to many, is how do you develop a data map? And it can be challenging because data is very much like water. It just sort of flows all over the place. You know, is it going into this particular system? Is it being used with this system? Has a team stood up this type of interconnection between various parts of our technology stack? It can get very challenging very quickly to keep a handle on whether you have consent to use data in the ways that you're hoping to within your technology stack. And the only way to get a handle on this is to develop an accurate map of how data flows through your environment. And having this map is a key to having a very defensible consent management framework in the event that you are asked questions by regulators or data subjects. So we strongly encourage folks to develop a data map as they're designing their analysis strategy and designing their consent management strategy. And the perfect time to do this is when you're at that design phase. If you're going to roll out a new analysis strategy, great time to start a mapping program to get cross-functional buy-in on the variety of services and processes that you're using. We always encourage people to pay particular attention to third-party platforms. These have proliferated as cloud computing and software as services have become more and more important to business. So we strongly encourage that you pay attention to those third parties. And on that point, we are always pushing people to choose wisely. The analytics tools, the software that you select really do matter. And to us, a key component of that is finding tools that are flexible, that you can mold. If you're purchasing software, if you're purchasing tools to build out an analysis function, we strongly recommend finding tools that you can customize and tailor or that are built, purpose-built to work within the European Union and understand consents, work with opt-in and opt-out capabilities. And that I think is a very important part of any analysis strategy and any consent management strategy. So I've been talking a lot. I'm very much looking forward to your questions and answering those questions. But I did have a couple of final thoughts. And the first one, and most important, I think, is that you really do need to think globally as you're designing an analysis strategy. We've spent the last 30 minutes talking about the European Union. I think that's important, but the story doesn't end there. I've listed here just a few of the laws that are beginning to come into effect. They're all going to have slight variations and differences. And so it's going to be very important as you scale your business to design a consent management framework, to design an analysis strategy with a global mindset around privacy and data protection. And I think that effective consent management programs are going to be measured really by their ability to be flexible for a variety of regional challenges. And so with that, I'm going to turn it back over to Jade. I know we've covered a lot and maybe frustratingly not enough. So I'm hoping to answer some more questions and I appreciate you guys giving me this chance to walk through my deck. So Jade?
Thank you very much for that, Peter. Yeah, we've got quite a few questions in the Q&A, which is fantastic. I would like to remind everyone that any questions that we don't get to, we will be collecting and trying to address as many of the most common topics as possible on our community pages. A link to our community pages will be included in the email that arrives in your inbox in the next 24 hours, along with the link to the video recording. But yeah, we've got 20 minutes left, so plenty of time to get lots of questions in. And I'd like to start, as we spent quite a lot of time on the topic of consent, with one question here. So first question to throw at you, Peter, what type/level of consent do I need from my end users in order to share their data with specifically analytics platforms?
Thanks, Jade. That's a thoughtful question. So what I would recommend in those cases is that you have a standalone consent that's called out in your privacy disclosures on your website or on your mobile application that would list what types of analytics platform you're using, the types of technology that it is deploying. So for example, is it using a cookie? Is it using an SDK? Is it using device fingerprinting, etc.? And then disclose what types of data elements it's collecting in general. And this can be tricky, right? Is it collecting information about device utilization? Is it collecting information about geolocation? But I would generalize that information. And then finally, I would ask and try to describe the purpose you're using that information for. Is that information something that is designed for product improvement? Is it designed for utilization? Are you using it for billing? And that's the level of disclosure that I would make. If you are using SDKs and these technologies on the client side, they likely also need to be included in a cookie banner. And so the cookie banner would have to have an ability for the data subject or visitor to opt out of using those tools on the client side. As I mentioned earlier, server side's a different story, but you would have to link those types of disclosures into a cookie banner and gives users some ability to opt out. So those are the types of customer-facing disclosures: privacy notice update, which is specific to the use, and a cookie banner, which gives the ability to opt out.
Perfect, thank you. So next question, I can see quite a few questions on this sort of subject as well. Can users still access your website without consenting to cookies so that they can still browse your site without any tracking? And I have seen a number of questions around that subject. If you're not collecting any particular personally identifiable data, do you still need to ask for consent simply for users to just browse your site, for example?
No, you don't. If it's not personal data as defined under the GDPR, and that's any information relating to an identified or identifiable individual, you do not need consent. So anonymization strategies are an important part of the picture. We found that it's very difficult to meet the GDPR's definition of anonymization. Because data is so often linked or linkable to other sets that do identify users, that can be a real challenge. But if you can anonymize information, you definitely do not need to have a cookie banner. And I do know of several use cases where that's possible. And to my point about making a wise selection on software, moldable solutions should be able to be tailored so that you don't have to collect personal data as defined under the GDPR.
And then a sort of similar topic regarding freely given consent. Given the example of a SaaS product, could the consent still be tied to a subscription? i.e. by subscribing and making use of your product, you agree that we can analyze and process data about how you use our product. So can that consent be implicit if an end user has some sort of subscription?
Yeah, it's a very thoughtful question. And I'll premise it by saying that the verdict is still out on that particular question. The European Data Protection Board, which publishes non-binding guidance, but reflects sort of the thoughts of the various data protection authorities amongst the European Union, has put out guidance suggesting that consents in the form of a contract for service may be invalid unless they are specifically separated from another part of the agreement. So there'd be a specific section that's called out about consent, and that the consent itself is specific to a use case. So for example, I'm using the software to understand how my users interact with my service, or I'm doing data analysis with the software. You would have to have a specific consent that describes that use case that's separate or called out from or somehow flagged in your license agreement, and that is agreed to. That arguably meets and satisfies the requirements that the EDPD put out. But again, the verdict remains open on that, but it is a challenging question. Our approach at Mixpanel has been to separately call out consents and to make sure that they're easily flagged, there aren't any pre-checked boxes, and that users have an opportunity to inspect our privacy notice and privacy practices prior to agreeing to share data with us.
Thank you. I can see at least 3 or 4 questions around the topic of a server-side solution. So I think that the people are generally wanting you to expand on that topic and understand a little bit more about what those solutions might look like.
Sure. So again, it depends on the architecture of your system and how the system is utilized. But if you can construct a system where users authenticate to or log into a service and then perform tasks on that service, you can monitor their use through a broader consent. And that would be what we were talking about earlier through these license to use agreements. And you can see activities that you would see client side, but you're collecting them server side. So users authenticated to the service and you are beginning to track and monitor their behavior on the server side. There's some challenges there, one of which is you have to demonstrate necessity. So you'd have to show that the type of analysis you're performing has a legal basis, be it consent, be it legitimate interest, be it necessary for the purpose of performing a contract with the data subject. But if you can establish that, we feel that server-side tracking is a way of avoiding many of the challenges posed by cookie banners and many of the challenges posed by browser-based blocks and other technologies that have limited the utility of client-side tracking.
Great, so there's at least 5 or 6 questions in the Q&A around a global standard for privacy compliance. So we've definitely got a global audience today, and a couple of specific US-based questions around the motivation for a US-based business to be compliant with GDPR.
Yeah, that is a very important question, I think, for US-based businesses, businesses based in Latin America, Asia, really the rest of the world. Is it fair or in our interest as a business to comply with a series of laws that were created in Brussels? And I think that's a question that each business has to tackle. Broadly speaking, the European Union has taken the position that the GDPR is something that they will enforce globally. And if you are collecting information, they call personal data, from data subjects, then those are anyone who's resident in the European Union at the time of collection, you are responsible for respecting their fundamental rights to privacy and data protection as enshrined in the GDPR. And that is a very broad set of standards that I think most companies that are doing business in Europe particularly have to weigh. There has not been a case that I am aware of where European data protection authorities have taken action against a company that's not physically present in Europe, but I don't see that. I see that more of just a function of the novelty of the GDPR, not as something that doesn't have the legal or extraterritorial rights to do. But again, that's a difficult conversation that those asking the question should think hard about and really consult with their own lawyers about. But I know it's a very thorny question. I've wrestled with it with many clients, including Mixpanel for a number of years.
Perhaps a bit of a specific question on consent. We have an audience member that's asked, can I ask my users for consent again at a later time, e.g. after a year, if they have once refused their consent for a specific data use?
That's a great question. I think that the short answer is, how do you want to ask for consent? So if the approach is, I would like to email a person who's told me I don't want to hear from you again, that's probably not on the table. If this is from someone who has begun to visit your site again, is interacting with your services, there certainly should be invited to change their consent settings. But again, it depends on the way in which consent was withdrawn or refused in the first case. And so I think I would need some more specific information about your particular use case. And we'd be happy to answer that on QBQ. Might be a great forum for that. But in general, it would depend on how the consent was obtained in the first place and what they withdrew the consent for in the second, to determine whether or not you could reach back out to them and ask them to change their mind.
And another specific question to throw at you around data collection and anonymization. Would sending internal customer IDs to an analytics tool, a random number if you just look at them, is that considered as personal data? If you were thinking about potentially afterwards putting them in a CRM and using them to identify a specific user, but not collecting specifically identifiable information within the tool on the platform itself?
Another very thoughtful question. The way I would approach this is I would look at the randomization of those numbers. And let's just say that you're using a hashing strategy where you're taking randomized data and hashing it into some identifiable data. The question becomes, is that linked or linkable back to personal data? Can you extrapolate from that some information that would identify an individual? If you can't, you have a very strong argument that it's anonymous, and sending it to a third party would likely be seen as not sharing personal data. The personal data would then be, the anonymized data would be processed, the results of that data would be transferred back and then stored in your CRM, where it may be re-identified, but you probably have consent for that use case, or you have a business justification for that use case under one of the other bases for processing. So that's a strategy that you could pursue, but the question is, how robust is that anonymization strategy? And that you'd really have to look at the technology underlying it, the strategy around it, and how easy or hard it would be to identify or reverse engineer an identity from that data. But in general, could be a very effective strategy.
Potentially a very important question here. Would we be in breach if we collect, I think that should say collect, oh, sorry, no, if we contact the customer via a contact number collected without having the GDPR management in place? The purpose of the call is to follow up on the resolution of the issue and user experience feedback. So if a number is collected for that purpose, but the end user hasn't been informed that that information would be collected through the GDPR consent management system that might be in place.
So if I'm following the question, and the way I would frame it is, we have collected a telephone number. We were not, or maybe not as clear as we could be, that we were collecting telephone numbers, and that we're then collecting that telephone number and using it to make a follow-on conversation with the data subject for purposes of ensuring that the product worked, or perhaps follow-on marketing, regardless. So the issue around consent there, and there are other ways to talk about this, and this one might be a great question for QBQ as well, but specifically to consent, if you're talking about European residents, you've collected information without their permission, and you haven't disclosed that you're using that information for purposes that you have designed downstream. And that gets you into a really thorny question about whether you have consent to use that data, whether you have consent to process it at all. And there may be other bases to do that under the GDPR, but from a strictly consent management framework, we would recommend that you make it clear to your users at the outset that you're collecting telephone numbers for this particular purpose, and that you're going to use that information to reach out to them as they walk through a business relationship with you. That would be our recommended best practice. But again, there are other ways in which you could come to a different conclusion looking at different parts of the GDPR. But strictly for consent management today, we would recommend having a more robust disclosure about what you're doing.
And a question around how long data can be stored for. If we collect information, for how long can we keep it? Is there a time limitation to keep the data? For example, if we are recruiting and the selection process is over, can we keep the information of the candidate to see whether she or he applied in the past? In various CRMs, they collect information after a certain time and make reference to GDPR.
Yeah, another thoughtful question. And I will answer it this way. The GDPR is silent as to how long you can keep data. All it says is you can keep data as long as that data continues to be relevant and necessary for the purpose for which it was collected. So if you are collecting information, you need to think about how long you need it and for which use cases you want to use it. And then you need to disclose that to data subjects to show this is why we're collecting your information. So in the example of a recruiting situation, you are obtaining their personal data to assess them for a candidacy or a potential position. but then you're also going to keep the information for audit purposes, let's say, to comply with various regional laws and requirements, perhaps to perform a sense of, well, did this person reapply? Did they fit into these types of categories so we can improve our hiring process? And so all of that would need to be disclosed. And then you'd need to determine how long do we want to keep it for? How long does it remain relevant and necessary? In the case of employment data, that necessity question is tough to pin down. One would think that a resume doesn't continue to necessarily be relevant after 2 years or 3 years. So that might be something to think through. Again, everyone's use case is a little bit different, but the key that I'm trying to drive home is you can set the necessity, you can set the relevance period, but if you don't, then it becomes more challenging to keep data for longer periods of time. In general, I also tend to advise the shorter the better for GDPR purposes. It's really difficult to justify keeping most information more than a couple of years. But again, that comes down to your individual use case.
In the last 5 minutes, just before we get to the final few questions, and I'll try to blitz through as many as possible, I would like to request everybody fill in a very, very short survey to give us some feedback on today's webinar. I'm going to post the link to the survey, hopefully, to everybody now in the chat. And yeah, if you could take just a couple of minutes to give us some feedback, we'd really love to hear from you. Back to the questions. So another question around storing the data. Assuming privacy policies get updated, one, do we have to store the version of the privacy collection the user consented to? Two, when the version of the privacy policy is updated, do you have to collect consent from the user again?
That's a terrific question, and one that's very challenging, I think, for many businesses. So the short answer is consent is tied to a specific moment in time. And if the conditions under which that consent materially changed, the data subject has a right to be informed, and they have a right to either withdraw their consent or revisit their consent. And this is why I chose in this presentation to focus so much on analysis strategy and high-level thinking, because I think as you look at the life cycle of an analysis strategy, you have to prepare for the fact that consents could be withdrawn at any time, and that if you materially change your analysis strategy, you're going to have to revise your notices, and you are going to have to let data subjects know that that has changed. And I think this is where consent management tools become very important. So you have the older copy of the privacy disclosure. You're going to change it. You have to change it, and then you have to give users an opportunity to withdraw their consent or opt back into that particular notice. Again, assuming that you're collecting personal data, assuming that the consent was given in a particular space and time, all those things would have to be thought through and given some thought. But the general trend is that consent represents a moment in time. And if it is freely given, it must be withdrawn, and it must be refreshed if there's a material change to what was consented to.
I'm going to try to squeeze in a couple more. Do you need consent if you use a chat line and people reach out to you via a form or a chat line on your website?
So the use case here would be something like a chat bot where there's a pop-up and it says, hey, I'm Tom, I'd like to chat with you about our product and service, and then the data subject begins to interact with that chat bot. That is a new area that I do not know of any regulatory guidance yet on. My sense is it would depend on what you're doing with that chatbot. So for example, is it interacting with the local device memory of the computer or smartphone of the data subject? If it is, it could arguably fall into the cookie category, but that would be a stretch, I think. If you are collecting contact information, personal data, you do need consent under the GDPR to process that information and use it for other purposes like marketing. And so for the chatbot example, I would definitely include something that links back to your privacy notice and so users can understand that and interact with it. I don't know that I would put a checkbox in there just yet, because I think you could argue that by interacting with this service and site, and as long as they're told about the privacy practice, that they have you have some argument for consent. That could change, but that's my thought right now. For web forms, I would definitely recommend that you have an agreement that says, hey, we're processing your data, we're going to use this information for these purposes. Do you agree? And then you should have a checkbox or some other button that's not pre-checked that they agree to. I think web forms are a much clearer case.
And finally, last one for today, is the IP address considered personal data?
It depends. I know I've been saying that a lot, it depends, but if an IP address is static and it's assigned to a particular user and a particular device, it arguably is personal data. If it's dynamic, if it's NOC'd, for example, or relies on an ISP that uses dynamic IP addressing, it becomes harder to say that it is personal data under the GDPR. So again, it depends on the use case. If it's persistent though, I think it's a pretty open and shut case that it could be personal data as defined under the GDPR.
Thank you very much, Peter. So I'm going to wrap up and just ask everyone again to click on the link in the chat and fill in the survey. And also just to say that we will be collecting all of the questions and trying to answer as many as possible on our community pages. You can expect the link to the community page as well as a link to the on-demand video of today's session in an email that should be with you in the next 24 hours. So thank you once again, Peter. Thank you everybody for joining. We hope you found the session informative, and we look forward to seeing you again on the next Mixpanel webinar.
Thank you, Jade. Thank you, everyone. Take care.